Thank you, Aleš, for the invitation, and thank you for your patience to stay here until this late hour. I will try to be as short as I can. And as Alice mentioned, my expertise is criminal procedural law, so I'm driving you back to the topic that has been introduced previously by Uwe, because we are going to talk about the use of algorithm-based evidence in criminal proceedings and the challenges that this brings to principles of the equality of arms. So I will be focusing on one aspect of the fair trial. My colleague Ugo Pagallo, who worked with me on this study, wasn't able to join us, and he apologizes. So three forwards, actually. So I use the term algorithm in the title of this presentation, and we all know that the term algorithms may have very different definitions according to the area of expertise that we are dealing with. And for the sake of this, for the purposes of this presentation, I will use Gillespie's 2014 definition of algorithms that refers to encoded procedures for transforming input data into desired output based on specific calculation. This is the concept of algorithm that I'm going to use for the purposes of this presentation. Second forward, we've been almost talking about prevention of crime today. The majority of the presentation today dealt with the issue of preventing crime. And by saying preventing crime, we mean that on the basis of a set of inputs, an algorithm can predict the likelihood of a criminal behavior that haven't occurred yet to occur. And this is what we've been talking about just right now. Patrolling neighborhoods, intelligent actions can be based on this kind of algorithms that are expressly designed to prevent crime. But this is the forward. My presentation is going to deal with the second aspect of the impact of algorithms with criminal justice, and this is to say repression of crime. Repression is different from prevention of crime because it deals with something that already occurred. Repression of crime, criminal law, comes into our attention whenever a criminal act has already been perpetrated. And in this case, after a crime has been perpetrated, algorithms can be used in many ways, can impact in many ways on the application of criminal law, can impact in various ways on criminal proceedings. Three main ways, actually, that have been mentioned today as well. The first way is impacting on bail decisions. Many kinds of algorithms can be used in those systems having bail systems, actually, to deliver bail decisions. Then, other aspect that has been already referred to today, another area of impact is sentencing, of course, in those countries having different systems of verdict and sentencing. And then third, in the gathering of evidence. And this is exactly what my presentation is going to deal with. So algorithms, in the sense that I mentioned, repression of crime, and in particular, gathering of evidence, and how algorithms can impact the gathering of evidence. I'm dealing with gathering of evidence and not on presentation of evidence in court. And I would say that there are two main issues that can impact on ways in which algorithms can impact on gathering of evidence. On the one hand, cutting-edge technologies, but also even very basic technologies can be used to intrude into private life, substituting traditional systems of intruding private life in order to gather elements and data about individuals. Second, those huge area of evidence that Uwe called big data evidence, which are not designed to be used in gathering evidence, but can offer enormous and countable amounts of data that can be used, can be relevant as evidence in a criminal proceeding. So this is what we are dealing with today. Wow, I forgot that I had this. So as I mentioned, this is the area of the presentation, and the idea of working on this topic came to my colleague and me, because last year, two European countries, passed two new laws regulating Trojan horses use in order to gather evidence in criminal proceedings. Italy and Germany did it. But starting to work on this topic, we realized that these brand new laws were almost old once they were passed, actually, because lawmakers cannot be fast enough to follow technology. And so we decided to reflect and to see whether the existing framework of laws and general principles existing in Europe lasts forwards. The presentation deals with Europe, actually, can offer some way to react to this strong intrusion by algorithms in criminal proceedings. So gathering data for criminal procedure purposes has to do, as we mentioned, first of all, with private life, intrusion in individuals' private life. And we all know that private life is a fundamental right, either on this side of the ocean and on the other side of the ocean. If we look at the US, we can mention the Fourth Amendment, just to frame it. If we look at this side of the ocean, we have to refer first of all to the European Convention of Human Rights that has been cited by our colleagues this morning as one of the main instruments of the Council of Europe, deeply and strongly impacting on the systems of justice and of criminal justice of all the European countries. And moreover, we have to deal with national constitutions, because the majority of our countries' constitutions provide for protection of private life as a fundamental principle within their framework. It means that on a more basic level, the majority of our countries provide for regulations of instruments for intruding private life through means like searches, wiretapping, room bugging. But these regulations, as I mentioned, are becoming more and more inadequate because they are getting not outdated, because police and law enforcement agencies can now use new instruments in order to intrude into private life. As I mentioned, malwares and Trojan horses are the most basic example that we can do. And lawmakers are trying to regulate it, but they are coming slightly late, actually. And so we have to look at the existing framework, legal framework, actually. So intruding, as I mentioned, intruding in private life is something that has been regulated and protected and prevented possibly by Article 8 of the European Convention of Human Rights, setting for protection for the right to private and family life. As you can see in paragraph 1, the European Convention of Human Rights protects family life in two specific places: home and correspondence. These are very traditional ideas and venues in which we think that, traditionally within that, private life goes on, actually. But this is immediately confronted by the fact that we can use today cutting-edge technologies in order to intrude in private life that is not going to take place anymore exclusively in our home and in our correspondence, actually. Moreover, paragraph 2 of Article 8 of the European Convention on Human Rights sets forth a list of conditions and a list of values that can be put in balance with the right to protection to private life. There are two main conditions. One is in accordance with law, so legality principle. Intrusions in private life should be provided by law, first of all. And second, this must be necessary in a democratic society, as you can see. These are the two general conditions that are provided for intrusions, public intrusions into private life. Then you can see a long list of values that can be put in balance with the interest to private life. The list is long, and you can see prevention, among others, prevention of disorder or crime. This is one reason that can allow legislators, lawmakers, and public authorities to intrude lawfully into our private life. So I'm not going to linger on the case of the European Court of Human Rights about Article 8, because this is huge, actually. But we can say, for the sake of of this presentation, that that case law finally worked out two main conditions at which the private and family life can be lawfully intruded by public authorities for criminal justice purposes. The first condition is, let's say, transparency principle, which is related to the provision by law, the legality principle. It means that in order to intrude into our private life, lawmakers need to pass law, needs to provide clear and transparent provisions. They may meet not formally law, they can be regulatory regulations actually, but the important thing is that they are accessible and they are foreseeable, of course. This is one condition. The second condition is the adequacy, let's say, the principle of adequacy. So the intrusion should be the last resort, actually, and should be in balance with the value that the public authority wants to pursue with that intrusion itself. So these are the conditions in which intrusion in private life for criminal purposes, criminal investigation purposes, is lawful. But even if the violation of Article 8 may occur, it doesn't mean that there is going to be a violation of the principle of fair trial itself. There's a huge case law about the Court of Human Rights, European Court of Human Rights, setting forth, clarifying that even though a violation of another article of the Convention of Human Rights has been breached, the fact that an evidence deriving from that breach has been used in a criminal proceeding doesn't amount per se to a violation of the principle of fair trial. This may be applicable to violation of Article 3, protection of life, Article 2, protection of life, and Article 3, prohibition of torture and degrading and inhuman treatments, but also Article 8, if we want. The fact that there has been a violation of that article, a violation of our right to be protected from intrusion into our private life for purposes of investigation, of criminal investigation, doesn't mean that there is going to be a violation of our right to a fair trial. The court says if the evidence is not the sole and decisive evidence on which the decision is taken, is based, there is not a violation of Article 6. There is not a violation of the fair trial. This is the point on which we wanted to focus. Is there a chance to get more protection from the existing provisions of the European Convention of Human Rights? Probably yes. We try to go straight to Article 6 and see whether the application of algorithm-based evidence can amount per se to a violation of Article 6 without the need to go through a possible violation of Article 8 and then an evaluation of the preponderance test and see whether that evidence has been the sole or decisive evidence on which the decision has been based. And our opinion is that yes, Article 6 can provide further and stronger protection by establishing violation of the fair trial in cases of application of algorithm-based evidence. As you can see, this is paragraph 3 of the Article 6 of the European Convention of Human Rights, especially dealing with criminal proceedings. It's a list of guarantees that must be provided in each criminal proceedings. These concur together to offer the defendant the right to a fair trial. And the court repeatedly said that the right to a fair trial is based on at least two main issues. On the one hand, adversariness must be always granted, and on the other hand, the equality of arms. And what does equality of arm means? This is a quotation from a decision by the European Court of Human Rights, quite an old one, but the quotation is always very useful and significant. The equality of arm guarantees each party to be given a reasonable opportunity to present his case under conditions that do not place him at a substantial disadvantage vis-à-vis his opponent. So this is the key of the reasoning of our study. What happens if an algorithm-based evidence is used in criminal proceedings? Is still possible to say that we are having a fair trial, we are respecting the principle of equality of arms? This was the question from which we moved, actually. And the matter is it possible to challenge accuracy of data that have been processed in an automated way, exclusively automated data, on the basis of an algorithm? Is it possible to challenge it within criminal proceedings? This was the question, actually. And the main answer is that it's almost impossible to do that for the defense, because it should be possible to have access to the source code. If I'm not wrong, I apologize with software designers being present here, but this is, I consulted them, and I think that this is almost the simplification of a true and existing problem, actually. If we don't have access to the source code that generated that data, or that datum, actually, how can I challenge the accuracy of that datum? And this is of fundamental importance in any criminal proceedings. The fact that one conversation occurred on 3:30 or 3:35 that occurred in this block or in another block here in Zurich is of fundamental, of crucial importance in any criminal proceedings. And the only way to challenge the accuracy of that data is to have access to the source code, actually. This is the point on which we've been reflecting. And actually, what we found out is that algorithms are bringing in possibly the biggest version of a very known problem, which is knowledge asymmetry, which is something that occurred and happened in criminal proceedings since courts started relying on experts. And this is nothing new, of course, but probably this is the highest, the ultimate scale of this problem, because algorithms can prevent the other part, and I'm talking here to defense, but we can also talk about victims, for example, to access to the functioning, to the code regulating the algorithms, and ultimately cannot challenge effectively the outcome of that algorithm. How can I say that this result of an algorithm is not precise, that this conversation didn't occur on 3:30 rather than on 3:35, actually? I have no way to access it. So we try to reflect upon this issue. Knowledge asymmetry, as I mentioned, has occurred anytime and occurs anytime that courts rely on scientific issues. But the matter of accessing to the codes is actually possibly the biggest issue that we have to discuss. Is there then an unavoidable violation of Article 6 when evidence is collected by algorithms? Are there ways to prevent these risks, actually? So there may be ways to prevent or to balance, actually, the risk of violation of Article 6. Transparency is, of course, transparency seems to be a possible solution for that. Transparency is mentioned by Directive 2016-6AO by the European Union, dealing with use of data, big data, in criminal proceedings. In Article 20, is mentioned as a fundamental and crucial issue to be taken into account by lawmakers in order to regulate software design, software that is intended to be used in criminal proceedings. This software should be designed with transparency in mind. And this is an issue which is very important, but this is a very initial stage. It doesn't say anything to us rather than more than the fact that designers have to take into account transparency issues. On the other hand, transparency may be not enough, actually, because even accessing to a source code may be not enough, because even the designer of the software herself may be not able to explain ex post the results of the outputs of an algorithm, especially when learning machines are concerned. So the designer herself may be not at ease in explaining the reason why the algorithm brought to those outputs, actually. So transparency may not be enough, may not be the solution for the problem, actually. So there seems to be other issues that can be taken into account, other softwares, of course. Zero-knowledge proof software, for example, seems to be useful in some conditions, actually. It seems that zero-knowledge proof are able to cast light on the criterion governing the decision-making process. Without revealing the input of the algorithms, this kind of software is able to explain and to cast light on the decision-making process. This can help in challenging the accuracy of an evidence that has been processed in this way, but this is not useful probably in any kind of situation that we are dealing with. For example, I think it's not useful in Trojan horses, for example, application, because I think this cannot explain exactly and cannot help in assessing the accuracy of the results of the Trojan horses application. Another issue, we mentioned it has been mentioned. There may be an independent certification of algorithm trustworthiness. This means that the court could appoint an expert witness whenever one of the parties of the proceedings casts doubts about the accuracy of the results of the algorithmic process. But there are issues in these solutions as well. On the one hand, the court-appointed expert could not be able to come to a reasonable result, as we mentioned, because also having access to the source code of that algorithm may not be useful to somebody who didn't design it. So the ex-post validation of the results of an algorithm process could be very difficult for somebody who hasn't got been involved in the designing of that algorithm. Second, there are, of course, issues related to the secrecy of this source code. We are talking about algorithms that are used in criminal proceedings, in criminal investigations, and for the sake of future investigation, it's not possible to to discover actually the source code. Third, in this case, the challenge wouldn't be a direct challenge to the trustworthiness of the data, actually, because this would come through an expert that has been appointed by the court, and the defense may not trust that expert. Fourth, in many countries, our regulations provide for appointment of parties expert whenever the judge appoints his own experts. This may bring to an issue which is very common in Italian courts, for example, but I'm sure in other countries as well. A battle of experts, each of them bringing in their opinion about the assessment of trustworthiness of the algorithm that may somehow confuse the judge rather than helping him in understanding whether the data that have been challenged are accurate or not, actually. So these are the current possible solutions that we've been revising through literature, actually. I recently started to cooperate with the IT department of my university, who is now working on a system to assess accuracy of instant messaging systems, in particular WhatsApp, and in order to set a set of software, actually, a platform that is going to validate a complete chain of exchange of information that can be useful in assessing the trustworthiness of the data that may be used within criminal proceedings. So, conclusions of this initial part of our study. Well, yes, we think that introducing algorithm-based evidence in criminal proceedings can hamper definitively the fairness of the proceeding, because this can hamper totally the equality of arms, because on this basis, one of the parties, and that party is, of course, the defense, because the defense hasn't got access to the best technology like the prosecutor has, because the defense has a direct economic exposure, actually. So this is going to strengthen the impairment between the parties. So in this case, and in this situation, we really think that using algorithm-based evidence may hamper the right to equality of arms. On the other hand, we think that it's important that we start thinking to possible solutions about that. We perfectly understand the fact that source code cannot be disclosed actually openly for the sake of future investigation on the one hand, but on the other hand, this phenomenon can push the fair trial aside, actually, preventing the defense to have any word, any possible actual effective challenge on the accuracy of evidence. So transparency is, of course, an important step that can help in those software that are designed expressly to be used within criminal proceedings. It's probably not useful for those big data evidence that you mentioned, data that are coming from, think of the Internet of the Things. These are not software which are designed to be used to gather evidence, but they can offer huge, enormous amount, uncountable amount of data that will be used in criminal proceedings as evidence. How can we challenge it? So this is the issue, and probably transparency is a good first step, but it's not enough. So second step of our research is, as I mentioned, working with our IT department and see whether there may be other solutions to prevent or to ease a little bit up this problem. Thank you.
Thank you very much. Thank you, Serena, for mapping criminal procedure rights implications, right, and offering some solutions. We have time for questions. Please, questions from the audience. Anybody? Yes.
Yes, thank you very much for this interesting talk. I would like to know, is there an empirical study of criminal cases involved in your study project? And how many cases, if this could be said? And the second question is, are there decisions or cases at the European Court of Human Rights which deal with the equality of arms against the backdrop of digital data altogether or AI-generated evidence? Okay,
well, this is the very initial stage of our study, so the empirical part of it has not been organized yet. As I mentioned, the idea of focusing on this topic came from the fact that Italy and Germany last year passed these new laws, and we found that these new laws were not offering protection enough against the risk. And we decided to see whether there were existing frameworks, legal frameworks, in order to protect the defense from these risks, actually. As far as I could see, but I may have forgotten something, there are no specific decisions by the European Court of Human Rights strictly related to this point. The issue is that the courts come to this point always passing through Article 8 of the European Convention of Human Rights. There's huge case law about the challenge of accuracy of traditional room bagging and wiretapping, actually. But we think that there's something different here. There's something different here because when traditional room bagging or wiretapping are at stake, there may be ways, even maybe not so effective, but there may be ways to challenge the accuracy of it in courts. Whenever that very same tapping or bugging has been done through a Trojan horse, actually, there's no way actually to try even to challenge the accuracy of it. And on the other hand, as you mentioned, this is another very important issue. The court tends to be immediately and absolutely convinced about the accuracy of the fact because this comes from an automated process. This is what we are trying to focus on, and you are trying to focus on, actually. This is the big risk. It's even higher than it used to be in traditional wiretapping and room bugging, actually, because here there's no way to access to it. It's not an analogical system that you can somehow revise. So this is the point. But the second step of the research, working together with IT department, is to settle an empirical research, which is not that easy to do in Italy, but we will try to do that. Thank you.
Thank you. Any other questions? This will be the last question.
Thank you. In Germany, before they adopted the law, and also a little bit in Switzerland, there has been some pushing for what they call here govware, but what is malware, the Trojan horses, that they have to be certified before they are used. And then we have the code with the court, and whoever wants to challenge it at least has some knowledge. What do you think about that?
Well, thank you. The brand new Italian regulation is very similar to the one you mentioned, and I still think that these regulations, as far as I could understand, are not effective because they are still related to the old idea of physical domicile and home and correspondence, actually. It would be probably more effective to have to root these new regulations on idea of digital domicile, probably, because I think that the protection that is given by this certification may be not effective. What do I mean? I mean that, for example, as far as the Italian law is concerned, the one that I know better, actually, there are limitations for the use of Trojan horses. You can do that if the person, and I think that the German solution is quite similar, if the person is located in a certain venue, you cannot do it in another venue, you cannot do that within her home, actually. But this is, on the one hand, it's impossible to follow quick movement of the person, and your smartphone or your laptop is always with you, so it's quite difficult to think that those limitations will be actually respected. It means that somebody is constantly stepping in and stepping out of the conversation, and this was possible because with traditional instruments, one telephone line was tapped, one room was bagged, actually. So that was a physical limitation of the interception. Now the interception can follow us wherever we want to go. And this is so important. This is the reason why it's so important to be able to challenge the accuracy of it. How can I, even though the law says you cannot do that if the person is staying in a place which is not a public place, how can I try to challenge the result of that Trojan horses bagging or wiretapping, actually? The reality is that these instruments are much more intrusive than traditional instruments used for wiretapping or interception, generally speaking. And lawmakers and scholars need to acknowledge this fact. The intrusion is much, much deeper and much more, let's say, definitive, actually.
Okay, thank you very much. We should wrap up a bit. I would like to invite everyone for a final round of applause for our speakers.